bunch of sentencing sort of letters that me and some other people from my office have submitted. So you can see some of the ways in which, at least in our office, we advocate for our clients and try to incorporate both storytelling, theory of the case, and a case is usually theory of what it is that we want to be putting out there for the court. There has to be sort of a thematic principle driving the document or your oral advocacy, because you want to get the attention of the court. You want to try to figure out a way to make your client or this case seem different than millions of other cases that the judge sees. And the only way to do that is to try to find unique ways to approach your client or the case. And that can be really challenging sometimes. And so that, I think that's part of the challenge of this. So I guess I wanted to kind of just talk about a couple of things. Okay, so do you think you guys are good or bad at sentencing issues approaching sentencing? I bet federal folks are like awesome at it. No. Okay, why do you think we're not so good at it?
I think that it's very easy to concentrate on the legal arguments and how the facts fit into your legal arguments instead of doing it the other way around, telling the story using the facts and shaping the law to fit that.
I think that's true. Because we're approaching it like lawyers and thinking legally about stuff. And although you guys have to do a lot of, unlike I think in state court, you guys actually have to do a lot of legal thinking in your sentencing memos, right? Because, don't you, about downward departures and
I think that's part of it, but I agree with Vanessa, but I really try to incorporate the client into the memo.
It's okay, don't worry about it. Okay, so
there may be legal issues, but
that's not really your focus.
Yeah.
Okay. Does anybody have any other sense of why we kind of suck at this?
Because we're still contesting the facts. Like in our gut, even if we've lost, in our guts, in our guts we're still saying, no. She threw the first punch, and I don't care what the jury just said. I know she threw the first punch. And
Right. I think also so part of us is that I call it trial psychosis. Like, so when you get to the place where you try a case, you so completely believe and are committed to the position that you take in a trial, right? That you can't allow yourself to see anything else, right? That's how you try a case. And so you get sort of tunnel vision about that, and then it's hard to let go of it. Like, you don't even feel like it's okay to let go of it because you've so totally enmeshed yourself in that place. So I think that's totally true. I also, go ahead.
Oh, I was just going to say, one other thing is, you were asking about like when to write and stuff, and I write a lot of Clayton motions, which
Those are motions to dismiss in the interest of justice.
but there's sort of an implicit plea.
That sounds lovely.
When would you not file a Clayton motion,
You really have to do it. You really do it very
It's very funny. I barely ever do it. When I first started practicing, when was sort of, I do not need sound.
Okay, right.
Thank you. I just have to click my keyboard to make it move.
Yes.
Okay, awesome, thank you. She's so cool. She does it, but nobody else can do it. to write a lot of Clayton motions if our clients were like dying of AIDS and were incredibly sick, and there was some reason that like prosecuting was just making no sense. I had a client who was like 90 and or 89, and he like broke the arm of his 93-year-old friend or something. Really?
I did one with an old man fight where he knocked out the other guy's fingers.
It was like that. My client hit the other guy with a dog chain. This was like my second year of practicing, and I think I tried the case, and then there was a Rosario violation, and then we were going to retry it, and then I wrote a Clayton motion. So like that. Very unusual, but I don't know. I don't
Anyway, the reason I brought it up is,
Yeah.
is I feel very when I write those, and I probably write about 2 to 3 a year at most, but I feel very formulaic when I'm writing those, and I'd like to sort of see how this
see outside the box.
see how this fits in.
So that's interesting. But part of the problem with that too is like the statute like lists all these factors, which is probably a little bit
Which is
similar
why it's
to-
formulaic, because it says you have to, these are the
you
7
have to set
factors.
forth a series of factors, and I think we think about a set of factors too when we approach sentencing, and what I think I'd like to see if we can get to at the end of this is to sort of push past that and figure out how to approach it maybe from a different place. So we have tunnel vision about our cases, which I think is true. So I don't know if I love this email. Okay. I also think when we lose, we get really depressed. Does anybody get depressed when we lose? I get so depressed when I lose. I just feel like really like despondent and negative about like the whole experience. And then you have to go back and see the same judge who you just lost a case in front of, and you have to like relive it. Like sort of the last thing in the world you even want to be like thinking about. You just like want it to sort of be over, and of course it's not for your client, right? But for us personally, like you've so invested yourself, and you just don't even want to deal. And I feel like sometimes it's hard to make yourself go back and say, this really isn't over right now, and I have another job to do. And I think that we have to force ourselves to kind of get past that. And I think we're also really negative about it. Like, what good comes out of sentencing, right? You kind of approach it and say, like, this isn't going to be good for my client no matter what it is. And then you sort of feel negative about it, and it's hard to like get up the like more, the sort of energy and like even to think positively about it. So, and we also don't ever really talk about this shit in training, right? Because we train about how to be successful, and we don't really talk about what to do when we're not. So I think it's just an important thing to talk about. I also think that we think about arguing with the other side. Like it just feels like there's this wall up. The judges in a place and the prosecutor's in a place, and we're sort of totally outside of that place, and we don't really look at it like it's like a new opportunity to kind of fight again. Somebody said to me last night at the pool before I was thrown into the pool in my dress that it's like a whole other opportunity to win, which I think is like a great way to think about it, right? Which is, if you're successful at sentencing and, you walk your client out the door when you think they're going to get sentenced to jail time, and the judge sees the humanity in your client and sentences your client to a non-jail sentence, and you're really not thinking that's going to happen, it feels amazing. I mean, it is a win, right? So I think that you have to think about it in that way. Like, this is a new opportunity for me to win. And so, think that. So, I think we need to be like, as creative as possible when we approach these things. Being formulaic is exactly the opposite of what we need to be doing. And I think, it's the same thing like when you do an opening. I don't know if any of you have thought about the work that we do as being formulaic. Sometimes people in our office, Brian and I work together, send around an email that says, can somebody send around a cross of a this, right? And I'm not saying it's not a good idea to look at somebody else's cross, but the cross of some witness that happens to be like an evidence collection team cross guy, right, in their case, is not your case. And I think a lot of times we forget that it's good to get background and like training, you know, all that sort of foundational stuff that you ask questions about of a witness. But in order to really truly do a theory-driven cross, who cares what the witness said in some other case, really? It may not have anything at all to do with your case. I remember there was a guy who did a closing last year at NCDC, and he had this thing, this sort of paragraph about history and some quote, I don't know, from the Civil War or something. And I was like, do you use that in every trial? And he was like, yeah. And I was like, don't do that. Like, you know, this was like his stock beginning closing. And, you know, if you're doing that, throw it away. Like, it doesn't apply to your case. Well, maybe it applied to your case once. But that doesn't mean that it's going to apply to your case. Every single case that you do, you have to approach it like it's the first time that you're doing anything creative for this case. And every approach that you take has to be different. I have never given the same structured opening statement in any two cases in the last 20 years. Ever. I mean, I wouldn't even think about doing it that way. Every single case is different. And I feel like sometimes we do get into like a little bit of a rut, like because, you know, oh, this is another robbery case. It's an ID robbery case. I've tried these before. And you somehow think you can just kind of interpose the stuff on it. It's okay to look at the thing you did last time. The one exception to that, I think, is voir dire, just as an aside. Like I just like Jeff Robinson said, like I have every voir dire I've ever done in my life in the book. So that if I'm doing another identification case, I can look back and say, what was I thinking about talking about this ID to a jury? Because that really can be something you can go to and look at again, and because it isn't necessarily fact specific, I mean, there's things you can talk about generally about this identification that you can reapply and then begin to focus in on your case. So we have to think creatively, and the question is like, how do we start doing that? You know, I think, like I said before, you want to think about the humanity of your client, like who is your client? See, that's why I need to go to the other lecture, because I can't even see my PowerPoint, because it doesn't fit on the slide. It's really bad. So you want to think about what makes your client unique and special and different than somebody else. You know, this is about a truly in-depth endeavor in talking to your clients maybe in ways that you haven't. I have sometimes found myself having conversations with clients about their lives, like I can't believe I've known this person for a year and a half and I didn't know these things about them. Because we're so focused on the case and getting information about the case that we don't dig into our clients' lives. There was, you know, they've had a whole life before you've met them. And the case was like a moment in their life. And maybe you get enough to think about whether you want to do it direct or not and kind of get some background. But really what's going on in their lives, where they've come from, and how it is that this is where they landed can be really complicated. So you want to think hugely about investing in that process. Either you do it or you get somebody to help you. If you have the resources in your office that you have a social worker or you can hire a social worker, you need somebody to spend time with your client and actually figure out what it is that's unique about them. The other piece of it is what are the impacts of this conviction on this person's life, okay? And I don't just mean they're going to go to jail, that sucks, being in jail sucks, period, okay? There are so many impacts on people's lives about what happens to them after they're sentenced, whether they go to jail, whether they don't go to jail, that it's sort of like this two-pronged thing. You want to think about your client and you want to think about the impacts on their life. And So that's kind of a lot of what we're going to be talking about, basically. So I think it's important to think first about sort of stepping back and saying, what does the court want here? Like, what is the goal of the court? What is it that they are looking to accomplish here? It's a little bit like sort of stepping back and thinking through the theory of the prosecution's case, right? When you're developing the theory of your own case. You want to sit down and do all the work that we did to develop the theory of our own case, right? To brainstorm and figure all that out. You need to know what the theory of the prosecution's case is too. If you don't do that thoroughly, right, you're going to be sitting in court at counsel table listening to the opening statement of the government, and you're like, shit, that sounds bad. Right? And when I say think about it, I don't mean think about it, I mean say it. I don't mean brainstorm their theory. I mean say it out loud. Hear how shitty it sounds, right? Because that's what the jury's going to hear. And then, so that you want to impose that idea here. What is the court thinking? Try to get in the judge's head. What do I think the judge really thinks is appropriate here? How does the court perceive this case and my client? And think about the goals of sentencing that we all learned about in law school, right? What is the judge thinking should happen here? Is this about, is this punitive? Is this about rehabilitation in the judge's mind? Is there some rehabilitative component to it? Like, where's the court coming at this case in the scope of sort of everything else? And then, of course, you want to think about what the prosecutor is going to be asking for. Now, I don't know about you guys, but in our jurisdiction, this is totally knee-jerk, right? The prosecutors just ask for the most jail time that they can get on any case, the most punitive sentence that they can think of. There's no thought put into this. There's no sort of discretion in their brains about what they think is appropriate. They don't talk about, like, in their brain scales. I'm curious in federal court how that plays out.
It's the same.
It's the same.
Yeah, they've got the sentencing guidelines, which are completely advisory now, but they just tend to ask for a guideline sentence. And matter of fact, it's not their policy in Chicago. It's not a written policy, but I believe that it's very much an office policy. You'll never go below the guidelines.
Right, they'll do the wink and the nod of, we would argue for, the low end of the guidelines, we think that's appropriate. Then they'll actually say, it's our office policy not to agree to a variance. And that's the best that you can get, that wink and the nod.
I mean, we get that sometimes, like if we're plea bargaining up at the bench, and we have, in New York, we have something called youthful offender adjudication, which is that your client's conviction is sealed for the purposes of a predicate status. So it's not a conviction, and the sentencing is reduced, which is a great thing, but the prosecutor's position is always the person should have a felony conviction and that they should have to do jail. But they'll go up to the bench and be like, well, we're not going to make a big deal about it, Judge. But on the record, they'll say that they want those things. So, okay, well, that's consistent, I guess, with what I expected. But it's interesting if you think about it, right? Like, why aren't they thinking, why aren't they saying, well, this just isn't as bad a crime as, like, these other cases, or why can't they see or concede on any level? Yeah.
I kind of asked a question like that in my office, and I was told when I started, they really just care about convictions. So they really give little thought to sentencing, which is why it's so easy for them to rely on the guidelines.
Right.
Yeah, and I think, especially after trial, I kind of feel like the DA is like, your guy took his shot, he took a risk, going to trial, I offered him X number of years, he took his risks, so now we're going to ask for the maximum.
Right.
He
So
gambled.
so they see this as like going to trials, like this is punishment for right.
Yeah.
So, I mean, so that's what you have to be thinking in your head, which is like, they're not thinking, and it's actually really sort of an opportunity for us, right? It's not like they're doing any work to get ready for sentencing, right? They're not doing shit. They look on their guidelines, they figure out what's the maximum jail sentence, and that's it, right? So this is us. This is all about us trying to sort of take control in the courtroom, take the power, take the story. And actually, it's a great opportunity. Nobody's telling really some alternate interesting story, right? They're just saying, you know, he did these heinous things that, you know, they're just going to talk about the case. They don't know anything about our clients except their records, right? They know what our clients' records are, and they know what they did in the case, and that's it, right? I think they're just, I want to go back, there was something else when, you know, this weird feeling about like why we don't really think too much about this process. I also think there's this weird conflict, right, about going, and I'm going to talk about this because I have a case like this right now, going forward to sentencing, knowing your client was convicted, knowing in your heart that your client did the thing that he's charged with, but you've been in this trial psychosis posture all this time, right? You know, convincing yourself and everybody that you know that your client is innocent, or that your story is awesome and that you can sell that story. And then you're sort of in this weird position, right? What does the judge want to hear from our clients at sentencing? They're sorry, remorse, right? And so, should you do that? Or does your client have an appeal? Are there appellate rights that you are compromising by having your client come into the courtroom and say, I'm sorry, this is why I committed this crime, right? I actually have that situation right now with a client who did exactly what he's accused of having done. The story of why he did it, I'll probably talk to you about it later, is really, really sort of sad and fucked up and crazy, but he did it, and there really wasn't a legal defense to it, except for maybe some sort of EED defense, but not really. And he's on lifetime parole for murder that he did when he was 17. So going EED wouldn't have helped me any, or him any, because he would have ended up in the same exact place he is right now. Extreme emotional disturbance. So some sort of defense where you can be looking for a lesser, like a reckless conviction as opposed to like a reckless assault as opposed to an intentional assault. So you're convicted just not of something as significant, as serious, maybe a nonviolent, I don't know how it works in your jurisdictions, but you know, it's the classic case where man walks into the house and his wife's in bed with her boyfriend and he shoots the guy because he's just overwrought. He's, you know, but my client really wants to tell the judge that he's sorry and why he did it. And his history is really complicated because of his prior murder conviction. He's now was convicted of assault in the first degree. He was charged with attempted murder, which we beat. I have no idea why. But my client basically slashed up a woman in her apartment, and the apartment was like a bloody massacre happened inside. Like, you can't believe what this apartment looked like from one person just getting slashed. I mean, like, there's blood everywhere. It was crazy. And, you know, so he really wants that. And I feel like the judge is going to look at my client and think he's a sociopath. Like, why wouldn't he think that, right? And I kind of thought that, honestly. Like, I'm like, all right, you did a murder, you were in jail for 21 years, you got out, you were out for 14 months, and now you slashed this woman up in her apartment. I'm like, I don't know if I really want you out, right? Like, it's a little scary. But, you know, when you talk to him, of course, he's a really nice guy, right? How many times have you said that?
Right.
Oh my God, what's the matter with you? But he's actually a really nice guy, and he is. And he isn't really a sociopath, frankly. And he has a really interesting psychological background that sort of makes the fact that this happened make total sense from a psychological perspective. So you know what? I hired a psychiatrist to interview him and evaluate him and both say to the judge, the fact that this crime took place makes total sense for this man. He's not a sociopath. He doesn't have a violent history he was in jail for 21 years. He never had like any kind of violent, sorry. Is that you, buddy? I just got the iPhone before I came here, and I have no idea how it works. So, oh, good, it's her. That's good. It's really complicated, though. So I called an appellate lawyer, and I said, look, my client really wants us to approach this sentencing this way. and go to the judge and tell him why this happened and how this happened, which of course, like, for the first 6 months, probably more, a year or more of my interactions with him, he absolutely denied committing this crime. Like nobody I've ever met in my life. So much so that I actually was convinced that he was innocent because of his own intensely committed position of his own innocence. So the fact that he's like in this completely other place now is sort of fascinating. So I got my social worker, because in our office we have social workers. I don't know if you guys have that. But so he went in and he did an evaluation and we got all his records and found that he really doesn't have any violence from the 21 years he was in jail, which is pretty remarkable if you think about it. And so I called this appellate lawyer and she said it's totally fine, that it's okay for him to approach sentencing this way if he has, she said if he has appellate issues and they're real issues, then the appellate court will acknowledge that. She said, and this is in New York, so you guys should do research in your own jurisdictions to make sure that this is right, the only way in which it potentially could hurt him is that if it was a case where the appellate court, thought that the client might actually be innocent, right? And they were trying to determine whether this was harmless error or not, that might impact on a decision. But there's no way anybody's going to think that my client was innocent in this case, no matter what. There are some really interesting appellate issues in the case, legal issues, but not anything that sort of would change whether or not the court thought he was innocent or guilty. So I thought that was really interesting. So I think that it's important if you're in that weird situation, because a lot of the times our clients don't, we don't want to take a position about the case or concede their guilt or innocence because we're, want to preserve their rights. That's a very different kind of approach. And you have to kind of meander your way through telling your story, whether it's about their life or the case, without talking about the case, without talking about acknowledging their guilt. But so I think that that's just an important, you need to figure that out as you're approaching, your whole theory of your sentencing piece. Okay.
Can I ask a question?
Yeah.
So if you, after the client gets found guilty and you first talk to him and he's still very insistent he's not guilty, do you try and discuss the possible beneficial impact of saying you're guilty at sentencing, or just, how far do you try and kind of push them to say, well, this could help your sentence if we,
Right.
even if you're still saying you're not guilty, if we decide to, say something else at sentencing?
I think I do that depending on what the case is and the facts. So, and I think that there are ways for your client to talk about being sorry without admitting their guilt, which is a fine line, but it's possible. So yes, I think if I think that it will help them, depending on the case and the judge, then I will talk to them. But the thing is the client has to be in a place which is that they've come to some moment in their life where they acknowledge what they've done and they're able to talk about it. I think our clients end up in the exact same position that we just talked about, that we're in. They've just spent the last year or two of their life in this posture, and a lot of it is posturing, right? That they didn't do it, or maybe they're innocent and they didn't do it, right? And so they're in that head, right? I didn't commit this crime. I'm innocent, or these people all fucked me over, which is usually where they are, right? They, it's always this person fucked me over, and the system's fucking me over, and which is often true. So for them to come to this kind of like, Jesus moment where they're like, okay, I acknowledge I've done something, that's really hard for our clients because they so are stuck in that place. I'm not sure that once you get a conviction in a case that you're going to get your client on the other side of that in the 2 weeks or the month or the 6 weeks you have before sentencing. I don't think it's that easy for people to come out of that place. So I think that, you have to figure out, is it worth it? Will it change anything? And can I actually get my client there in order for it to matter? I mean, I have a client, I actually brought his sentencing motion that I wrote. Yes, I do lose cases. For some reason, I have all these shitty cases to try right now. I don't know what that's about. All these dead dog loser cases. But this was a particularly awful case. They kind of all are, aren't they? All are. It's an awful case. So my client, it's a little bit about like the Brown case, I swear. It's like as close to the Brown case, except that the roles were a little switched. So the complainant was a young girl who, actually she was 21 at the time of the trial, but when she came into the courtroom, she looked like she was 12. And I am not kidding you. And her physical appearance was so bizarre. She was very small, like short. She had these huge breasts, and I think because she was on all kinds of medication, psychotropic medication, and she was a little heavy, but when she opened her mouth and talked, she sounded like she was like 12. So the whole appearance was so bizarre, and she spoke in very strange ways, I think, because of medicine. Anyway, she had a very long psychological history. She was borderline, she had borderline personality disorder. I had all of her psych records like this. I'm not kidding you, like in this huge binder. And I thought, how can I lose this case? The complainant is so fucked up. You know, the cross is going to be easy, not easy, but whatever. I thought I had like so much to work with. So my client was charged with forcible sodomy, what do we call this now? Criminal sexual act. Criminal sexual act is basically sodomy. They just changed the word. So, anal penetration in a stairwell at 8 o'clock in the morning in her building. Not great, guys. My client had kind of a long record, but not for any kind of sexual offense, but all kinds of stuff. And his story was that he met her at the bodega, which is where everything happens in the Bronx. Everything. In the morning, and he was getting a sandwich, and he said, "Hey, what's up?" And he thought she was kind of cute, and approached her, and they were talking, and they walked across the street, and he was like, "Could I walk you home?" And they walked home together, and he was like trying to give her a phone number, and he was flirting, and he sort of walks her back to her building, and they go into the staircase, and he's into the entryway of the building, and he's chatting her up and trying to get her number, blah, blah, and he says they start kissing, and they go into the stairwell, and one thing leads to another, and they get a little carried away, and they have sex, or sort of have sex. It's a little strange, their sexual encounter, but there's no penetration according to him. Anyway, he ejaculates on her, and like on her underwear, and he, according to him, his story was that she had her period, which was true, and he didn't realize that she had a period, so when he stepped away from her, he had blood all over him, and he was like, totally cursed her out and freaked out that she didn't tell him that she was having her period. And so she runs into her apartment, and she goes and tells her grandmother she was just raped. There's a 911 call, and people are upset. Not a good 911 call. And he leaves, and months later, there's a cold hit DNA, meaning there's a DNA hit. She's never made an ID, nothing. There was no way to link my client to the case except from the semen that's on her underwear, and there's a match. And my client is basically being hunted by the cops in the Bronx, and her poster's up, and it's crazy. So he comes into our office, and he walks in, and he's like a walk-in client. And I got it. And I'm like, why did I pick up the phone? You know? And so he became my client. And it was a crazy case, but she turned out to have all this crazy history and blah, blah, blah. And the biggest problem in the case was she came into the courtroom, and she looked the way I described, and she behaved like a 12-year-old. And the biggest problem in the case was the jury and me could not wrap my brain around the idea that my client would have wanted to have sex with this girl. And the fact that she would have had consensual sex with my client. Like, it just didn't make any sense, which is, I think, the biggest problem with the Brown case too. That's why it's so painful for me to work on that fucking case. Yeah.
Was there also the race element like Brown, or it was just the?
She was Latina and he was African American.
Okay.
So there was a little bit of the race element in there. And so anyway, my client testified, not horribly, not great, but not horribly. It wasn't awful. He did fine on direct, but cross was a little bit not so great. So at sentencing, he would not concede that this was forcible, ever. I mean, and I actually to this day believe that I think he was probably drunk or hungover from being drunk or still drunk from the night before. And I think she, like Paula Crane in a lot of ways, couldn't really engage in a normal way sexually with a man. I think that she probably really liked the attention. She had a totally fucked up life. And I think she was probably flirting with him, and this got too far, and she couldn't sort of stop it. And she probably didn't say no in the ways that my client could appreciate. My client's also a little immature and sort of juvenile in some ways, so I think it was really a case sort of about miscommunication, probably in truth. So when it came time for sentencing, my client wanted, he wanted to say, I'm sorry for what she had to go through. I'm sorry that, she saw it this way. I'm sorry she's so hurt and damaged from this, but I didn't force her, right? He just couldn't go to that other position, and I'm not sure he had to, right? But the judge was so fucking pissed that he was still sort of blaming this on her. That's the way she perceived it. That he was saying, I'm sorry she couldn't get this quite right. And it almost made her more mad, I think, that he was only willing to kind of go halfway, and his halfway made it seem like he was blaming her. Because her perception is that he was blaming her the whole time, and that he was still doing that. And so, in an effort to try to get some remorse and sort of, speak to the judge in a way that I thought would help, I think ultimately it sort of backfired. And she saw it not as remorse at all, but something else. And even though I, orally tried to argue to her why, in fact, this was remorse, she just couldn't see it. And she was going to fuck him anyway because she hated the case and she hated him, and the victim was so vulnerable. She, of course, came in and made a statement. The victims all do that in the case.
Oh, yes.
Doesn't that just suck? It's just the worst. It's the worst thing ever. I just did a sentencing on a homicide case. My client was with his brother, and the brother stabbed the decedent 21 times in the back, totally high in PCP, totally crazy. And my client was just kind of there, and then helped cover for his brother afterwards. So my client got an unbelievable deal. I got him a plea to criminally negligent homicide, which is a non-violent, the lowest level felony there is. And he had been in jail for like 3 years, so he basically got out. But the co-defendant, the stabber, went to trial. So that case hadn't happened yet. So the whole family came in, because this was probably their moment. I was like, what's going to happen? That guy's going to go to trial. He's going to get acquitted. And I have to sit here at this fucking sentencing and listen to this shit, right? But so, I'm feeling really good, right? I got my client a great fucking deal. I did the suppression hearing. It went really well. My client was really happy. And we come to the courtroom for sentencing. Oh my God, they all came. Like the whole family came. And this woman stood up there, his sister, and she talked for like 40 minutes about how no more, whatever his name was, no more Johnny at every birthday, no more Johnny at holiday dinners. Like 40 minutes. I was dying. I was like, where's my iPod? I just wanted to disappear. It's just the worst. So you gotta also you gotta prepare your client for that, right? You gotta sit down and say, this is gonna suck. This is what these people are gonna say about you. They're gonna call you the worst names you could possibly imagine in your life. This is worse than the trial, right? The trial, they're just going to talk about what happened. Now, they're going to attack you personally. This is going to be the worst thing you could possibly imagine. They're going to call you names and call you the worst things that you could ever think of. You need to figure out how you're going to deal with that. You need to think in your head about what that's going to sound like and what it's going to feel like. Yeah.
Just out of curiosity though, when they reduce the charges like that at sentencing when
Yeah.
the victim gets to speak,
Yeah.
and I see the prosecutor do it sometimes too, they try and argue the crime he was charged with, not what he pled out to.
Of course.
I mean, isn't there, I mean,
No,
correct?
there's nothing you
Like-
can do about that.
Like, we had this guy who was charged with murder and aggravated battery, and was convicted for both, but the murder got dismissed on appeal. And he comes back, and the whole conversation was about how we can't charge, we can't take into consideration that violent, they said, as they're saying, we can't take into consideration, that's all they got.
Right.
And they hammered the guy for an aggravated battery.
I mean, for the people who lost this person in their life, just for half a second, let's try to be human beings and go on the other side of it, right? You know, your brother gets stabbed and killed by somebody, and the guy that did it ends up getting a good deal, and the case gets dismissed on an appeal for some reason, right? When you come in to talk about your brother, you're still going to come in and talk about him the same way. Whether the prosecutor can talk about whether it's a violent crime, I mean, they shouldn't really be able to refer to those facts, but the family, they still lost this person in their life, however way they did, and they're not going to change their own perception of it. And they also perceive the case in a certain way, and even if the evidence in the case doesn't seem to come out consistently with that, that's where they're at, right? I mean, in that case, they were talking about all the shit that my client did in the case, and I'm like, that's not true. But, you know, they have a right to speak. It's not like you can object to what they're saying. They're just going to say what the hell they want to say. So you got to prepare your client for that.
I mean, there's also the situation if you have a trial and maybe you beat the top charges. You know if the judge thinks they should have gone down on the top charges,
Oh,
the
they're
judge
getting
is still thinking
fucked.
about it.
Oh, yeah. I was just on the way here, I was telling Deja a story about a client of mine in a homicide case. We beat the murder on a false confession, and the guy went down on the gun. And he was doing, he got 8 years in federal court on a drug conspiracy case, so he was already sentenced on that. And I was in front of one of the best judges in our courthouse, and he gave my kid on a gun 12 years consecutive to the 8, and strictly on it. And so he's doing 20 years. Like, it didn't matter that we fucking beat the murder, because he didn't believe that this was a false confession, right? And so he just punished him like he got convicted. Right?
Those are the hardest cases for me because I'm in federal court and in New Mexico, and I often get clients where they've got a conviction just prior to or going back over to state court.
Okay.
And we can, if we get them at the right time, we can, but you never know, you know, like they get written in from the Marshal Service and the county or the state lawyer doesn't know that they've got a federal case coming. And then you've got, if it's before, the sentencing guidelines go higher because they've got
Because they have that prior contact.
It's horrible.
Yeah, no, that's true. I mean, I assume this works like this everywhere. I don't know if that's right. So you can get, in New York, you can get concurrent time in
Right.
state court with a federal sentence, but not the other way, right? That's the way it works, as far as I understand.
Right, right,
That's my
that's
understanding.
right.
Okay, so that's also just sort of a tricky thing, right? Like, you want to be, if you're in state court, you want to be that last sentence in court so you can try to get that concurrent time. And that's what I actually expected to happen in my case. But my judge was punishing my client for what he thought he did. He didn't care what the jury said. So again, that's where you got to go, right? That's where we started this conversation. You got to figure out what the judge is thinking, what the judge wants, and how to talk to the judge about why they're wrong. Figure out where the prosecutor is coming from. That's easy, right? We just said that, and start to then begin to figure out how to get at that.
About the victim,
Yes, I don't even know how to say that. Go ahead, yeah.
Well, that in essence always screwed me too, that the victim come in, I don't know if there's any, how you deal with that, but they come in, as you say, and say stuff that's not true. You know, I had one where we had an agreement on a sentence, the judge could have gone higher, so the victim's family comes in, and then says all this stuff.
think you can, but you have to do it in an incredibly respectful way, right? So what I did is like, you know, this whole family came in, sister talked, the brother talked, and then they brought the mother, who was like, you know, this older woman, I don't remember where they're from, she's Spanish speaking, the matriarch of this family, and she was, and the worst part is she forgave my client. I fucking hate that. She's like, you know, I'm a very religious person, and I have forgiveness in my heart, and I forgive you for what you did. Oh my God, what am I supposed to say now? So, don't be nice, what are you doing? So, but they had these preconceived notions about what my client did. So I actually got up and I said, you know, I really respect these people for coming in here and speaking about the loss of their life. Like, give it to them. They're people. They're human beings, right? They lost a person in their life, really important to them or whatever. And say, you know, and I appreciate them putting forth their feelings about this. They did say some things in this courtroom that just aren't borne out by the facts of this case, and we all know that, right? So don't, you know, be like, you know, this motherfucker's lying, you know, don't take like you don't want to take an aggressive tone with these people. They're, you know, they didn't do anything, they're just there because they, you know, sad and they lost something in their life or whatever. So I think it's totally okay for you to say to the judge, you know, it's perfectly understandable that these people are upset. It's perfectly understandable that they want to see my client responsible for things that he frankly isn't. You know what I mean? Like, I think that it's fine, especially if everybody concedes that those are the facts. You know, I'm sure the prosecution would agree with me that. You know what I mean? Like, make this all like everybody understands this. And while I understand why, you know, a lay person, especially somebody who, you know, has a personal investment in this, would perceive this way, that just isn't true. I think you have to do that, because you certainly don't want the judge to be swayed by shit that isn't true. I mean, that's just, you know, that's not okay. So I think that's how I would deal with it.
We have requirements that the court only consider reliable evidence, so in our memos, we usually put together ahead of time the quotation from the case law, so that even if we're not going to jump up and interrupt, a lot of times the court will say, oh, Miss So-and-so, I appreciate what you're saying, but let's talk about this, and he'll stop them.
He will, well, yeah. I mean, that's, you know, if you have a good judge, that's great. I mean, I don't see any reason why you can't sort of address, and we get to go last anyway at sentencing, right, so you can incorporate your comments about that in your statement, whatever you want to say. Okay, so sorry this isn't really very well here. I don't know how to fix this.
Control minus,
Make it smaller?
yes.
You can come up here and fix it for me if you want.
I think I know how to do it.
Yeah? Okay.
Yeah.
Okay, so this is what we're talking about, right? Ask yourself, what do you want to happen to your client, right? Like, what is the best outcome for my client? What do I think would be a good result here? What does my client want? Have you ever had that conflict where you're like pushing and pushing and pushing for probation, and your client's like, I don't want to be on probation, right? I'd rather just do 6 months in jail or what, right? So you gotta actually have that conversation with your client. Like, what do you want? What are you capable of doing? It's okay. What's my client capable of doing? Is this a setup for my client to just fuck up more down the line in the future? We have, depending on how your sentencing works, like your client could end up getting more fucked if they fuck up on probation or some, sentencing like that than if they just took the deal up front or they took a little jail time or whatever. So you really want to think about that and sort of figure out what your client wants to. Okay, so these are the things that you have to know before you sort of step into this. Obviously, you have to know the sentencing rules in your jurisdiction. If you don't know the rules, learn them. You need to know, obviously you guys know sentencing probably like the back of your hands, and if you don't in federal court, like you got to know the guidelines and you have to get a sense of what, And obviously included in that is just, I imagine you all appear in front of some of the same judges over and over again. You want to talk to, if you're sort of new practicing, talk to as many people as you can, find out what kinds of cases this judge hates, the kinds of cases that the judge doesn't think is so horrible. They're all just people and they have their own opinions and ideas about shit. Talk to as many people as you can about where the judge sits on certain things. And then you want to think about the other stuff, right? Not just whatever the sentencing rules are in terms of incarceration, but all that other crap. Parole, if you guys have parole, post-release supervision, if you have that, we have that in New York now. SORA, do you guys have Sex Offender Registration Act? Okay, is that the most fucked up shit ever? Fines, orders of protection, other orders that are involved in the case. You can't go near this person, you can't go to this location, you can't have contact with these people. And the impact that those orders all have on your client. So that was just a total failure? Yes? Okay, then you want to be able to figure out what, do you think it's the angle of the?
It's just the angle of the thing.
What crazy, right? Why would that be
Yeah.
just, oh yeah, there must be a way to do
I
that.
thought I could move it digitally. Couldn't.
Have you tried to move that?
No, not manually, but.
Do you mind if I stand up here in front of
Be
you?
careful.
There's,
Oh, I'm not being
wait,
careful.
hold on, there is.
No,
one.
that's what I was just playing with.
The remote, this remote, is
Yeah,
that, what is
go for
that Sanya, what is that?
I know, I think we can keep it there.
That's good.
Nice.
That helps.
There's the lettering on the.
Yeah, the lettering's still a little messed up.
It's a little messed up, but it's you guys can read it now.
We can understand.
We're good.
Okay, okay, alternatives to incarceration, programs that your client is eligible for in prison, and whether or not the court is the one that has discretion over that, or this is just a corrections prison thing that the court has no discretion over, okay? So you want to know all that stuff. And this is sort of the piece that I'm not sure how many of you guys think about or do in your practice. It's a very big issue in our office. If you guys know anything about the Bronx Defenders, collateral consequences in this, sort of other impacts that things have on our clients' lives, okay? Immigration, housing, employment, public benefits, education, family, voting rights. Like, all of this shit is impacted on the fact that a person just has a conviction, putting aside what else happens to them. And the kinds of sentencing that they get can also impact on those things. I printed out from, it's the Legal Action Center has a website called Roadblocks to Reentry, and it's sort of a state-by-state description of a lot of the questions that, like the things that impact on our clients collaterally as a result of having a conviction. So I brought a couple of them, like I have Louisiana's and I have Georgia. I don't think anyone's here from Mississippi. South Carolina. So if you guys want to just look at what this looks like, it's like a series of questions and the impacts that these things have on your clients' lives. It's a great resource. You should try, you need to know this stuff. You need to know it as much as you know your sentencing rules.
What was that again?
It's called Roadblocks to Reentry. It's the website, I guess that it's from www.lac, which is the legalactioncenter.org. Our office also has something called ReentryNet, but this is really just New York-based information. This website has a state-by-state assessment of the impacts that convictions have. And then you want to figure out how to understand your client best. And again, that I sort of, we touched on it a little bit before. I mean, how do you figure out how to know your client? Talk to your client. Talk to people in your client's family. If you need help, figure out that you need help. You're not a psychologist. You're not a social worker. We all have like some exposure to all of these things, but that's not what we do. We're not specialists in drug rehabilitation. We think we are, because we deal with it all the time, but the truth is do you have any real sense whether or not your client can and will succeed in treatment? What kinds of treatment will they succeed in? I mean, I think I know these things because I've been doing this for such a long time with exposure to so many clients, but like, do I really know what the right kind of appropriate kind of treatment is for a particular client? I mean, I could say what I think it is, but I don't, you know, I'm not trained to do that. So, you know, if you need help, get it. Figure out what you need and figure out how to get that help. I know your offices are all probably very conscious of money and financial resources. But if you feel like this is going to make a difference for sentencing, like I do in this case that I was just talking about, I mean, do I think it's going to ultimately change the outcome? I think my client's probably going to get 20 years anyway. But is he going to get 20 or 21 or 25? Well, that might actually matter for him. So I thought it was worth it. I don't, you know, at trial, I did everything that I could think of to win his case. My feeling is I still have that same responsibility. I have to do everything that I can think of to try to get him the lowest sentence that I can. Even though I'm depressed, I'm upset, you know, like all of those things that I said, I'm still in, you know, I don't even want to look at this fucking file. It's like on my floor and I just want it to go away, but we have to do that. Okay, let me just. Okay, so what do you guys think are some of like the preconceived notions that the judges have of our clients? What do you think?
That addicts don't recover. They expect to see them over and over.
Oh, I was going to say something about that actually before when I was talking about like experts. You know, there's also some interesting research about treatment, when clients are best and most likely to succeed in treatment in their life. And there's also some stuff about aging out of crime. If you have like a client who's a little older, and so there's sort of I guess it's psychosocial research on some of these things. So that's another way to approach stuff. Like my clients at, you know, blah, blah, blah age, the likelihood of him continuing as a repeat offender, you know, is going to do that based on the research. There are ways to argue things. So, yeah.
I do all of juvenile work and the adolescent brain stuff that really goes into their early 20s. I don't personally think that lawyers use it enough. I mean, the juvenile judges are very used to kind of hearing it. If anything, we don't get enough play on it. Because they're like, yeah, that's all we see as young kids.
Right.
But trying to get those people in my office who do all adult work, you're like, if you're not telling the judge that an 18-year-old is fundamentally different than a 25-year-old and the choices they make, that they are going to grow up and get out of this, then I think it's a real disservice. And the Supreme Court has said you should use it, but we're so not.
No. So yeah, I mean, exactly. So you need to find out where your client's at and figure out how to explain who they are as a person, whether they're an 18-year-old and they have unique, you know, characteristics, whatever. I mean, even the place where a 17 or an 18-year-old is at in every way, shape, or form in their life, right? In their decision-making, in their maturity, in their ability to make choices, to see the consequences of things, right? Like, they don't, right? I mean, how many of you are 17, right? Like, what were you like when you were 17? Like, did you do totally stupid shit because you couldn't, like, even conceptualize it? And so you impose that on sort of the places and the ways in which our clients live. In very poor communities, they have no resources, they don't have a mother, they don't have a father, whatever their circumstances are. And you take all of those same qualities, right? You know, in our county, our clients always get the opportunity when they're young, not always, but sometimes to do like a program, right? And the program that some of them get to go to is in Manhattan, which is a 50-minute train ride, 45 minutes from their neighborhood in the South Bronx. Doesn't seem like that big of a deal, right? These are kids who have never been off their block in their lives. And I am not kidding. Like, never. Their entire entire lives are on their block, they go to school, maybe, and they come back to their block. They don't go anywhere. They don't go into Manhattan. They've never been in Manhattan in their lives. And they don't have the money to get on the train to go to the program and to come back. So going there, just getting there is hard. And then if they don't stop smoking marijuana, they want to put them in a program, a residential program, because they smoke weed. It's like, I was on the phone once with a counselor at the program for like an hour screaming at him, like, why do you think this is going to help? I don't even get it. I cannot wrap my brain around how putting a 17-year-old kid in an institutional residential setting, sometimes with other drug addicts, right? 24/7 is going to help them. I mean, did you want to be in a place like that when you were 17? I mean, all that 17-year-olds want to do is rebel and kick back. And like the idea of putting them in a place like that and telling them to stop smoking weed, that's just not happening. So I cannot tell you how many of our clients end up, like they go to the program because, you know, they have a Rob 1, so they have a robbery case with a gun. And the only way out of that shit case is to take the program and the possibility of getting probation if they succeed. So they go to the program and they can't stop testing positive for marijuana because they've been smoking weed for the last 5 years and they can't stop and they smoke every day. So then they can't stop smoking weed, so they send them to a residential program and they fuck that up and then they end up upstate for like years. I have a kid, they want to send him upstate for 5 years because he smoked weed. So that's just crazy shit. So that's where I'm at with the judge. I'm like, Judge, and then, okay, so then what's the next argument? The next argument is what happens to that kid if he goes upstate for 5 years?
Well, he learns to be a tremendously good criminal.
He's done. He's done.
But what the, and this is the other thing, the preconceived notion, is what the judge is thinking, is, hey, I gave you a chance, you knew what was gonna happen to you,
So
and what else can we do with you?
So what's the argument to that? Like, how do we think past that? What do we say? I gave you a chance.
So the chance is not the chance. The chance is it's like a false premise. It's just a Hobbesian, right? You're gonna do this or you're not gonna, or I'm gonna lock you up in the first go round. Of course you do that, right? Of course you do that. And of course they have the magical thinking of, I can do it. I'll stop smoking weed. Yeah, lady, I can do it. I can manage that this time.
Or they don't even really think that. What are they really thinking?
I'll get another one.
College.
I'll just,
Just
yes.
let me out of here. I
Right.
don't give a fuck what I have to say I'm
Right,
gonna
right.
do. Let me go home, right? Do they really get that?
No.
Because he's 17 years old,
Right.
right? He doesn't get that. So, right, it's a Hobbesian choice. And the kid who makes that promise cannot conceptualize of what is going to happen to them in 6 months if they don't do it. They can't see it, they don't get it because they're a kid, right? So,
Well, the risk reward is just totally off, right? Their ability to underappreciate the risk. You know, and I've had the gigs where I sit there and I'm like, let's do the pros and cons, and you make a list of cons that are a page and a half long and like one pro, and you're like, but all those cons will never happen. And they believe that. Like, you're like, no, I'm showing you, like, see,
Right.
that's not,
You're
it
getting
doesn't
past that, you know
matter.
what the probation officer is gonna say, and the judge is gonna believe is we've tried everything with this kid. What else can you do?
Right.
We've tried everything,
Right.
we've given them this,
Everything.
this treatment,
We
this.
tried to stuff them into the
There's nothing
one
else we can
program that we have that is not a fit.
exactly. So you need to start thinking like how to explain that to a judge. And you know, honestly, like these judges, they have kids, right? They do. They have children, and I know
And their
kids are
kids
not
smoke
these
weed.
kids.
no, they're not. But you know, maybe they're not these kids. But you need to say to them, take your kid and put your kid in that kid in this environment. I mean, I'm just saying that I think you just have to start to think about the crap that's coming out of their mouths and figure out, you're all smart, right? Figure out how to begin to argue against it. Or my new position is, fuck it, I'm not sending any of my kids to that fucking program. Like, it's just not worth it. I gotta find some other way because they're not understanding that smoking marijuana, first of all, is it easy to stop smoking marijuana when you smoke every day?
When everybody's are doing it.
That's it.
You're tired.
All of them friends are smoking all the time. What
Except
are
they
they
say then
supposed to
you gotta
do?
get them out of this environment then.
Then they wanna take them to treatment,
Another, another preconceived notion that judges have, it's not so much about our clients, but that they'll get help in prison. And these programs in prison don't exist, and when they exist, they're totally ineffective.
Or they're full until their sentence is
Well,
served.
they're
Right.
also in prison. I mean, so let's actually, just the decision that came out yesterday that we started talking about before, it's Tapia versus the United States. So basically, the court had ordered this female client to do a 51-month prison term. But the purpose of why the court sentenced her to that much time was so she could complete the residential treatment
Oh,
program.
yeah, I remember.
Yeah, in federal court, they have to, in order to get the 500-hour treatment program, you can't be an illegal and you can't have a gun no matter what. And so half of the federal drug clients have guns, so, and it's hard to get in, and you have to
And you have to
have
have a
certain number of months left in order to complete the
What did they
program.
rule?
So they ruled that you can't impose a prison term to assist in rehabilitation. That you have to, the term has to be set, and then whatever rehabilitation programs or services that they get, that's great, but they cannot be based on this notion that I'm sentencing you to this term because you're gonna be able to get treatment. But, so that's just interesting. I think it's an interesting decision. But I think that, we want to just be thinking about, what the court wants to do and ways to get those things. But in federal court, clearly, I don't know the specifics in terms of the sentencing guideline for this person. If it was a choice of, you have to get, lesser, whatever, 24 months, or you can get 51 months plus this program. But whatever it is, I don't know if there was some option for this person not to get a prison term, probably not, I'm assuming, right? So, that decision just came out yesterday, so you guys should get that for those of you who.
Okay, I got a suggestion for the sentencing you have up there, but I know you're judge.
Yes.
My office just started a new database called Law Manager, and one of the things as we're rolling it out that's really neat is that it's a searchable database by judge, by incoming charge, by conviction charge, and right now it's not much, but give it 3-5 years, and you're going to be able to type in. You type in Dumango burglary, and you can see all 50, what happened on the last 50 burglaries that were tried in front of her. So if you can start, if you start now in your offices, you can kind of just develop that.
Yeah, I mean, you can do databases for all kinds of shit, like cops, that have complaints against them, all kinds of shit, but that's great. For sentencing purposes, I think that's great. And this is just another issue, so I had the rape case that I told you about. So, it didn't occur to me, when my client was convicted of the lesser offense, yet again. We have a lot of compromise verdicts in the Bronx. And, so the jury did not convict him of the top count, the sort of forcible sodomy, but convicted him of criminal misconduct, sexual misconduct, some lesser offense. But, so he was alleged to have touched her breasts in the hallway, and then had this anal contact in the staircase. So it didn't occur to me in the moment when the jury came back with the verdict that, he could get consecutive time for this. But so I just was like, all right, this is okay. He got convicted of this lesser offense. He's still going to beat the plea offer. Didn't feel so horrible. We're all walking back to the office, and I'm like, oh my God. The sentencing law in this area on sex cases is horrible. Absolutely horrible. So again, in your jurisdiction, figure out, can you get consecutive time for 2 separate acts? What does that mean in the context of this kind of offense? So here was a little quandary for me. I'm thinking in my head, are they going to ask for consecutive time here? Should I address that in my document that I'm going to submit for the court? What if they want
That's right, you don't want to give them ideas.
Suggestion, it seems like a bad idea. So, so we did the research and the case law sucked. Like, really difficult to distinguish our case from some of these other cases. Although, just recently, there was a very good decision that came down from the Court of Appeals in New York on this issue, which is a good decision and helpful in this area. So this is a weird area of the law. If you touch somebody sexually here and then do it again here, those are could be deemed separate acts, even though it is one crime. I mean, how do you separate, did you put your hand on her breast and then on her buttocks? Fuck, that's two different things? Like, how's that? But, so the case law could be good or bad for you in that area. So what I ended up doing, just as an idea, throwing it out there, we created two separate documents. So what I did is I created my sentencing document, and then I did a memo of law on the issue of whether or not consecutive or concurrent time was appropriate. And I didn't file that. I just brought it with me. And so when the prosecutor got up and said she wanted consecutive time, I said, well, I actually have a legal memorandum of law on this issue, and I'd like to hand it up to the court. And the DA looked at me and she was like, fuck you. Like, you have a brief on this? Right? But, of course, we lost anyway. But, I also got to file that with, that goes up on appeal too. It's an interesting issue on appeal. But so you want to think about, what's the prosecutor going to ask for? How do I deal with this? Do I include this in my memo? Is this something separate? Do I want to show my hand? Like, what do I do here? And of course you can call the prosecutor too and be like, hey, what are you asking for? But I fucking hated the DA so much in this case that I didn't even want to look at her ever again. So I wasn't going to call her. So again, this is like, knowing your judge and so the judge that's about to sentence my slasher guy that I told you about with the prior murder conviction, he's the one that sentenced that other kid to consecutive time on the gun. So he's not a good sentencer. He's a great judge. He lets you try your case, but he's terrible on sentencing. So I'm thinking that the judge is thinking my client's a sociopath, right? So I'm trying to think about, what is the judge thinking about? What does he think? Where is he at? And what do I do to address that? So now you need a plan of action. So you sit down and figure out, do you have a team of people to help you in your office? Or are you doing this solo? Okay, in my office, we have a huge team of people to help us with lots of stuff. I have social workers, we have civil lawyers, we have immigration lawyers. We have an enormous full staff of people who can help me with collateral consequences, all this crap, right? But if you don't have that, and you're doing this solo, you are the team. You need a plan of action and sit down and figure out what you need to accomplish what you want to get, okay? And you want to start making a plan for yourself. What do I need to accomplish? Is how do I get this done? Okay, so I don't know if anybody said this here. I can't believe it. This is like the total NCDC thing, like when I was here about rocking with your client. Anybody talk about client interviewing? We didn't do a lecture on that, right? What does that mean, rock with your client? Not that. It means like seriously hang out with your client. Like don't just like go into the interview room and ask them about what happened in the case and be like, see ya, right? You gotta hang out with your client. You gotta spend some time with him, talk to him. He's a person, figure out what is going on with your client, okay? And then you have to figure out what the effective ways are to communicate what it is that you know about your client. Okay, so again, you gotta read who you're talking to. What are the things that are actually gonna be compelling to my audience? Just like we do with a jury, right? You're like, oh, I have this interesting argument or story to tell the jury. Is the jury gonna buy that? Is this something that this jury can relate to, right? You're thinking all that as you're trying to figure out what story you want to tell to your jury. You got to do the same thing here. You got to figure out whether you can do this. Is this a life story you want to tell? Is it a trial story you want to tell? Is it the story you never told at trial, the real story? The story that maybe happened but didn't really fit into your legal defense, and now you have a different story to tell. And you want to be creative. The same way you guys were being creative to get your openings together, right? thinking about the order that you want to talk about this,